Welcome back, everyone. Thank you so much for being here. Thank you so much for being part of Incident Response Forum Masterclass. We have a terrific panel coming up now on retail, which really was one of the first places where incident response lawyers started to do work. I want to encourage everyone to keep chatting in the chat room, in the chat area, and interacting with one another. It's a unique aspect, and keep asking questions. Even if the panel doesn't get to your questions, we're going to send them to the panelists after this is done. So hopefully they can answer them then. So I'm really just blown away by how well the audience is. I think there were 30 or 40 questions in the ransomware panel, and all kinds of legal advice being doled out, including by one of our panelists, Chad Pinson, in the last one, which is great to watch as well. So let's get to who's on this panel so we can start talking about retail. Let's start with our first panelist, Seth Harrington, part of the ever-growing IR and privacy legion at Orrick, where, like so many of our experts today, Seth counsels clients through all stages of privacy or data security incidents, navigating the array of legal issues that arise, managing the response, and defending clients during the regulatory and litigation that ensues afterwards. But what also makes Seth so perfect for this panel is, even among the pantheon of IR experts we have here today, his retail experience really stands out. Just a few of the companies he's helped: Arby's, Landry's, Hilton, Sally Beauty, SuperValue, the Home Depot, Aldo Group, Genesco, Heartland, TJX, Wyndham. I could keep talking and talking. These are the companies that he has worked on. This is Seth's first incident response forum. We are so thrilled to have him here. Welcome, Seth.
Thank you, John.
Our next panelist, I think our next panelist might be one of the most experienced data breach lawyers on the planet. He, like Seth, he might even beat Seth in terms of numbers, has worked on just about every major data breach. Some you can mention, like Yahoo, and others you can't mention. Well, we can't mention those, but he's worked on quite a few. I met Paul Luehr of Faegre Baker Daniels when I was at the SEC, and he was my counterpart at the FTC in charge of their internet program. We not only worked cases together, but he and his wife tried to fix me up on dates, which I always appreciated back then. Now I'm married, it's okay. What set Paul apart from most everyone else at that time and now was he didn't just investigate internet fraud. He took his cases to trial. Paul is a bona fide courtroom trial lawyer. He loved it so much, he went on to become an AUSA, and then he joined Stroz Friedberg as general counsel and managing director when it was a tiny startup just breaking new ground on the juxtaposition of law, business, and cyber. Now he leads the privacy, cybersecurity, and data strategies team at Faegre Drinker. Let me make sure I'm pronouncing it right, Faegre Drinker, and brings a special perspective. One as a consultant, a federal prosecutor, a regulator, a general counsel. That's a lot jam-packed into one person. Welcome, Paul. So glad to have you here.
Great to be here, John. Thanks.
Well, how great is it to have this next person willing to participate on this panel? Kevin Moriarty, a senior attorney in the Division of Privacy and Identity Protection in the Bureau of Consumer Protection of the Federal Trade Commission. And he engages in a variety of policy outreach, investigatory work regarding data security and privacy. He was the lead attorney for his department's only two federal court litigations: Wyndham in the District of New Jersey and D-Link in the Northern District of California. I believe, were you and Seth on opposite sides of the coin in that one? Okay, awkward. Sure. Okay, well, we'll continue anyway. I watched Kevin deliver a presentation recently, and he spoke about how when he begins investigating an incident, the first thing he looks at is what sort of data security standards, if any, the company is following. He also mentioned that if he finds compliance with some standard, that will often stop his investigation right there. Quote, "It doesn't make sense for us to go after companies that are trying to do the right thing." He sounded so reasonable, thoughtful, and diligent, and a true credit to the FTC. Welcome, Kevin, to your first IR forum, and thanks so much for taking the time to be here with us today.
Thanks, John.
Excellent. And finally, my former colleague and friend, Chad Pinson, president of Incident Response at Digital Forensic and Investigations at Stroz Friedberg, which is now a part of Aon Insurance. Well, what makes Chad so perfect for this panel is not just that he is truly a jack of all trades in the cyber arena, be it cybercrime, digital forensics, malware reverse engineering, it's all in Chad's bailiwick. But unlike, I believe, just about all of the consultants today, and prior to joining Stroz Friedberg, Chad enjoyed a national litigation practice at Baker Botts, focused on data security, privacy, data access, and data theft matters, and is former chairman of the State Bar of Texas Privacy and Data Security Committee. This is a very powerful combination, and we could not be more thrilled to have my friend Chad on board with us today. Welcome, Chad.
Thank you. Appreciate it.
Excellent. Well, Paul, you're going to be the moderator, so I will hand it over to you and have a great panel. Thanks.
Thank you so much, John. Now that we're all done blushing from John's introductions, I think that comes with the territory. Very kind of you.
Nobody needs a better intro than John Reed Stark.
That's right. Be somebody you want talking to your mother, right? You make us all proud. But thanks very much, John. That's very kind of you. We do really have an all-star panel, and we wanted to jump right into it. This will be a lively group. It's great to see. We've got people who've even been opposite sides of the table. This group of dudes can hopefully show that not just the women can be respectful, but also the men can be respectful when it comes to people, you know, who used to sit on different sides of the table. We're all trying to approach the same issue, namely cybersecurity for the benefit of the general public. Lively, I can tell you, because Chad and I, we were just talking, and we immediately started arguing about what the best stats are out there. But I do think it's helpful to maybe start with a couple stats to kind of level set. I think a lot of us in incident response just jump into it, and we forget that for our clients, you know, this really boils down to real dollars and cents. And so to throw out a couple of numbers, the Ponemon Institute does their annual survey, and in 2020 they found that consumer breaches were $2.59 million globally, or $2.01 million if you're separating out just retail. They actually make two different distinctions there, consumer and retail. And I think those are the relevant figures for us. Interestingly, as John mentioned, retail really used to lead the pack. Now retail is somewhat behind the world average. The world average for breaches, according to Ponemon Institute, is $3.86 million, about $1 million and a half dollars higher than what retail would normally see, and about 3 times less than healthcare, which leads the pack in terms of different industry sectors. I know it really shows that there's been a change in the market, and that's one of the things we wanted to talk about and kind of emphasize. And Chad, I'll throw it to you first. I know you've said while retail still sees breaches, there's been a real shift in the market. And talk to us about what kind of shift you've seen.
Yeah, sure. And you know, Paul, I shared with all of you guys as we were getting ready for this, you know, I think of retail as B2C. And so when I'm talking about retail, I'm thinking about anything in that space. And I look back, getting ready for this also just made me feel a little bit old. I handled my first one of these in 1999. And, you know, it's kind of gone from there. And in 1999, really setting aside APT, and we all know, you know, APT, advanced persistent threat, nation state attacks, but setting aside APT, for a long time, the game in town was B2C attacks. That was the way for hackers and attackers to monetize. Get a credit card, get a driver's license, do identity theft, you know, make charges, that sort of thing. That's how you monetize. The last panel really is one of the defining reasons why things have changed. Cyber extortion and ransomware have completely changed the game so that you don't just need a B2C company anymore in order to monetize. And in fact, it's a lot easier to monetize using ransomware and cryptocurrencies and cyber extortion because that's an in-demand pay play. Whereas monetizing, you know, PCI numbers, monetizing the other things that you can get out of B2C to do identity theft, it's a lot harder. I was actually, you know, on dark web, deep web earlier this week, just getting ready to talk to you guys. And, you know, a single verified credit card with an excellent credit limit, with a name of a person that people would recognize, I won't share it. It was going for $100, which at one point that was a lot more expensive. And then I also saw batches of credit cards unverified for, you know, $150, $200. That's cheap compared to what it used to be. I think that, Paul, the point you're making, asking me this question, and I'll just say it and then get out of the way, is for B2C, the game has changed. still a target, still a giant problem, but it's moved from just being a PCI and customer and employee identity records problem to a business disruption, cyber extortion, loss of goodwill type of problem, that it's just changed everything. And if we had done this same masterclass 4 years ago, everything would have centered off of B2C, because that's what everything revolved around that wasn't APT. That's just not true anymore. And I need to B2C plus healthcare, but it's just not true anymore. Now, the manufacturing company down the street can be popped, business disruption, pay, and you get the same monetization out of it. That's the state of play right now, in my mind. And Paul, the only other thing that I'll add, and then I'll shut up, is it used to just be credit cards, but with a lot of the changes in chip and PIN, the other thing that everybody just needs to be aware of and see is gift cards now are almost just as valuable as credit cards because they're easier to monetize off of. So, of the thousands of incident response matters that we work every year, that's what I could share in the 3.5 minutes or so that I was talking, that maybe will bless the audience.
That's very helpful. And we'll talk a little bit more about PCI, but I also think some credit should probably go to the PCI industry groups for getting ahead of this, having a professional standard. It's not perfect, of course. We know plenty of PCI certified companies have been popped over the years, but I do think that industry push has helped in terms of reducing fraud. And of course, the introduction of a new type of card. The EMV card, it's harder to replicate as a fraudster. So I think those are some of the things that are important to recognize. And one other thing I think you brought up previously, Chad, gift cards, but we're also seeing, I see it especially in the hospitality industry, points for loyalty cards, or points to
Travel.
be able to get a car, a hotel room, things like that. We're still seeing some activity there, right? At least I am.
Absolutely. And some, I wouldn't even just say some, you do LUN checking on credit cards. There's not a LUN check formula for gift cards necessarily, or at all in many cases. And so it's easier to guess and replicate gift cards. It's easier to get access to them. It's easier to use them anonymously because, frankly, there's not a name tied to these things. And so gift cards plus points plus loyalty programs, travel, hospitality, but it can even be something as simple as the bodega down the street that keeps points for you. If it can be stolen and monetized, people are still doing it. And because of some of the technology that's injected itself into credit cards, it's a lot easier to do it in other spaces, and people are taking advantage of that.
Yep. Kevin, I want to turn to you, and I'll help you out a little bit here as an ex-FTCer myself. I'll give the standard disclosure for you. Kevin comes to us with his own views. He does not speak on behalf of the commission or any particular commissioner. Did I remember that right, Kevin? Is that good?
Sounds right. I'm not sure we still have to make that
No?
disclosure, but I don't think anyone's going to confuse me.
Okay, I just over-lawyered it. Sorry.
FTC.
That's what we do. But Kevin, I know, as John mentioned, you worked on some of the larger direct-to-consumer cases the FTC brought, D-Link, Wyndham, and we haven't seen a lot of retail cases in recent years. And I was wondering if first you could talk about that, and then talk about a little bit of the low-hanging fruit that we still see out there that the FTC did address in 2020 and 2021.
Yeah, sure. So, I think it's interesting. I don't, that quote that John gave in his introduction definitely sounds like something that I've said. It's, I think when you start to investigate a company and they kind of describe a standard that covers their industry or covers their field, and how they complied with the standard or how they found themselves out of compliance and endeavored to comply with it, that's a significant piece of information for the Federal Trade Commission in terms of how our limited resources are best spent. If there's already significant economic incentives in place and a structure in place to try to keep companies with good security, there's less of a role for the FTC. And before I get too far into that, I think one of the places you can kind of see our acknowledgement of the role of standards is that in the two cases that we did litigate and then eventually settle, in Wyndham and in D-Link, rather than try to reinvent the wheel in terms of injunctive relief, in both of those cases, we just said, look, there is a standard, in Wyndham it was PCI, there's a standard that already exists in this field. So with some modifications, the way the company can best kind of be in compliance with this FTC order is to be in compliance with PCI. And we ended up we kind of followed the same model in D-Link, where there's but unfortunately I can't remember the standard that we use now, but that was, instead of data security, that was secure software development. There was an existing standard, and it kind of covered the field. It was a widely accepted, agreed upon standard that was a useful thing for companies to follow when they're trying to develop software in a secure way. So we just dropped that into the order as a way for the company to, rather than try to parse through language invented by the FTC, they can look to this standard. So in both of those cases, we've kind of acknowledged the role of the standards outside of the FTC as being a significant, important consideration.
If I could ask, Kevin,
yeah, go ahead.
What I see sometimes, especially with new upcoming businesses, it really goes across the spectrum. But I see it especially in healthcare, where everybody's coming out with a new app, and I see it in retail, where people are excited to get out there and sell the latest product. They often think about security after the fact, after they're pushing the product forward. And to me, as a former regulator, it would make a huge difference if they had a program and they just wrote it down. And it sounds so simple, but I'm always surprised how many companies I still run into that claim they have good security, and yet it's not recorded in any formal policies that you could point to.
Yeah, I think that's true. I think if a company was in a field that somehow didn't have an existing set of standards, and that company wanted to figure out what would a security program look like, frankly, they could look at one of our orders and just at the very least start with the 5 provisions that we have in every order, which is to have a written program, have someone be in charge of it, evaluate risks to the data every year, develop safeguards to address those risks. This I know is sort of high level basic stuff, but having that kind of checklist that the company can go through is, obviously there's the most important thing is to keep the data safe, but if you're sort of assuming that you're going to be breached, which I think all companies do, the secondary purpose of following those procedures that's in all these FTC orders is if your lawyers ever end up in a room with the FTC, they can say, look what we did. We followed these things. We still got breached, but that's, having the story to tell is part of steering clear of the FTC. In some ways, I kind of feel like the FTC is, it's like, we have limited resources. We can only go after so many companies. We're not going to go after every company because we shouldn't. It's not strict liability. If you've been breached, that doesn't mean that you had deceptive or unfair practices. But even if we wanted to, we just don't have the resources to do that. So it's kind of like the saying about the bear. You don't have to outrun the bear. You just have to outrun the guy who you're running with. And so if, as a lawyer, you can sort of establish that your security or your incident response was better than somebody else's incident response that was happening about the same time, that's a good way to, just get the FTC to focus its attention on somebody else. But definitely when we start an investigation and a company comes in and says, look, we thought that there'd be a breach, and so this is how we planned for the breach, and this is what we did when the breach occurred, and this is what we're doing now. That's a compelling story for the FTC investigators, and that's enough to, oftentimes that's enough to be the end of the case.
You heard it here, folks. Outrun the other person, have
Yes.
a plan, write it down.
And the
these are
FTC is
pretty-
a murderous bear.
That's right. Well, you said one of the things obviously you need to do is just protect the data. And maybe you could talk about a couple of the cloud cases that caught my
Sure.
eye. Ascension Data and SkyMed,
Yeah.
I would put them in the cloud category. I mean, what happened there? Where did people go awry?
And SkyMed is actually a great case for this panel because it's actually an incident response case. But both of the sort of the common theme in both of these cases is something that we actually see a lot. It's something that we saw in the Uber case as well, is that everybody's using these outsourced cloud providers and everybody's screwing up the configuration. And so security researchers are hopping online and they're figuring out all the different ways that all these different outsourced cloud providers have are exposing these companies' data. So, you know, the big picture story here of both of those cases is, you know, I've never configured cloud storage myself, but, you know, pay attention to that. It's not enough that it's in AWS and AWS is secure. The point is that the way that the data is accessed has to be secure as well. In SkyMed, it was a case about a company that provides emergency medical services, and as part of the registration process, you had to provide medical information. And of course, on every single page of their website, they had a HIPAA compliance image, and they were neither HIPAA compliant nor did they need to be HIPAA compliant. It seems like that image was just there to give people comfort when they were providing their sensitive medical information. And, you know, as an FT, like unfairness cases are hard to prove, but when somebody just does something like transparently deceptive like that makes our lives really easy as FTC lawyers. So, you know, that was sort of the easy part of the case. The more interesting part for the purpose of this panel is that it appears that SkyMed did not have sort of a plan when they heard from the security researcher that their database was public. They found that it was public, and then they immediately deleted it. And the problem with that is that they didn't actually ever figure out what data was in there. They didn't try to figure out if they could determine whether it had been accessed, and then they actually proceeded to then communicate to their customers and say, you know, as you may have heard, we found this breach. We just want to let you know that there was no health information in the database. We want to let you know that no payment information was exposed, and as far as we know, no one accessed it. And none of those things were true. I mean, well, it wasn't true that they confirmed that that was the case. It was, they just simply had no idea because they had deleted the database. And so, you know, it's obviously when you have an incident, and having a security researcher tell you that there's an exposed database qualifies as having an incident. You know, you have to sort of go back to your protocol. You can't just like, let's solve the problem as quickly as possible and just delete it. I think the other interesting thing in SkyMed, and I think most companies know this, but it's good to take calls from security researchers. And the response to getting a call from a security researcher is not to threaten to sue them, or is to not kind of file away their concern in a bucket of concerns, but it's to like take it seriously. And that's kind of one of the easiest things a company can do to start trying to protect the security of their data.
You make a great point. And again, practice pointer for our crowd, and it's great for this crowd because it's what we do for a living. If there's an incident, guess what? The FTC is telling us we need to investigate it. You can't blow it off. So that means that all of us who are attorneys and technical first responders, we've got some work in this area because not just the public, but the regulator expects it. Expects us to do the investigation. I think it's interesting you point out in SkyMed. I noticed that too. The seal that they put out there. Obviously, HHS has come out and said we don't actually recognize any particular HIPAA seal or certification. So you have another government agency saying watch out for these things, and yet they use that seal. We saw a similar, I think, situation in the TapLock case where they overstated kind of what the product was about, the smart lock. Maybe you could talk about that.
Right. Yeah. I think I don't have as much sort of lessons learned from TapLock, but this is one of those cases where the consumer protection of the FTC is not, it's not all just about data and data security and privacy, but it's also just about like actual security. And one of the hacks of the TapLock lock was, not only could you was there various ways to get around authentication on the website, but it was actually very breakable because you could just kind of unscrew the back of the lock and unlock it sort of the old-fashioned way, physically.
I hate it when that happens.
Yeah. That's the one aspect of the lock they didn't get, the actual physical lock.
Yeah, and I think they said it was unbreakable. And I think those of us who provide advice in the security field, I mean, one thing we really have to still watch out for, a lot of CEOs will push the CISOs, the marketing department, and say, I want to make security the vanguard of our marketing statement. And we just have to be cognizant of the fact that when you make those statements, they have to be absolutely accurate. And there is some risk around that. So I think over time, we will see security become more and more of a market, what would you say, a market point or a point of consumer advocacy, but we got to be careful. And obviously, the FTC said that TapLock wasn't. But I wanted to, before we jump to Seth, I wanted to talk a little bit about where the FTC has gone on the remedial side in some of these consent orders that have come down.
I don't want to, if Chad wanted to jump in, I'm happy for him to jump in.
I'm sorry, Chad, I didn't hear you.
And I'm hoping that this will invigorate some conversation from Seth too, but I just have to jump in here because I was watching the chat in the last panel, and then you guys alluded to it, and we keep using the term security researcher, which I think is a controversial topic. And I have to speak up on behalf of my clients because, I mean, look, I'm saying this to everybody out there. If you're a security researcher, there are many of you that we work with that are fantastic, and we're glad you exist. There are some people out there that's another word for crook, right? And I don't want to have the impression left that every time somebody reaches out and uses the term, hey, I'm a security researcher, and that everything after that and is going to be good, helpful, and the way you react to it is the way they drive it. Because some of that and is, we found these call outs going to a known site, and if you don't do blank, which is usually pay us money, we're going to tell somebody and embarrass you, and that's a crime, and we're going to turn you over to law enforcement. That's not fair play. And just because it's been brought up twice, and maybe in earlier panels, I've tried to listen to most of them, I think that this is a really complicated thing that we just brushed over. And it applies in retail as much as anywhere, but especially so because with the customer aspect of B2C or consumer aspect, the sort of ability to shake down, threaten, and embarrass is heightened. And I think that's the other part of the problem. And again, I want to communicate back. I work with, I hire, I collaborate with security researchers in really great ways. But some people, it should be quotation marks around the word, and it's, it's a shakedown and extortion. I couldn't let that go. I'm sorry.
Yeah, no, it's a great point, Chad. And I think to Kevin's point earlier, what it raises is, do you have a plan? And in my own experience in dealing with some retail customers, I'm seeing it more in the smart device area, where people are out there with maybe a security lock for your company, for your house, but it's interacting with the web in some way. Or there's some device that you put in your car, for example. I'm seeing that there's a fair amount of activity among quote unquote security researchers in that area. And some of those people tend to be more traditional manufacturers, and they're really stuck if they don't have a plan in the first place to deal with those people. Whereas if you have a plan and you say, I have a bug bounty program or a responsible disclosure program, you've heard it termed in different ways, right? You can at least take that researcher and say, get in this lane. If you're not in this lane, I don't want to deal with you. But if you don't have a plan, you can't push them into that highway where you want them to travel. You can't hold them off on that newspaper, full press media disclosure that's going to not just embarrass folks, but might put some of the public at risk for their safety. That's the one I think I really worry about. So I think the idea of planning ahead, like Kevin said, the importance of just thinking about this stuff ahead of time, I think is really important. And Kevin, if I could come back to you, I think that does get to remedial measures. When you're at the FTC and you're handing down some of these consent orders, or the commission is handing down some of these consent orders, after the LabMD case, what's happened? What are you looking for?
So, and Seth probably can talk even more about the LabMD case than I can, but since that case came down, there's been a lot of changes to our orders, and some of it is in reaction to that case, and then other is just sort of that need to re-examine the order sort of occasioned an opportunity to look more closely at some of the, basically the provisions that we used in these orders came from the GLB safeguards rule, like almost as long ago as your time at the FTC, Paul, like, ancient times. And so this occasioned an opportunity to look at this stuff again. And so some of it was trying to get a little more specificity to address the court's opinion in the 11th Circuit, but also just some new stuff that we've started doing, like creating a greater emphasis on making sure there's C-suite responsibility, trying to figure out ways to enhance the significance of cyber and privacy decisions at the company by enhancing the consequences as part of this. There's a lot you can see. It's still in flux. There's a lot of changes that are happening. It's always easier for us to negotiate these settlements when there's kind of the one settlement, but there's been a lot more thinking about it that the FTC has done recently. So it continues to change. So we have Seth to thank for that.
Yes. Seth, that's a great transition to you. Speaking of things in flux, I'd like you to maybe address both what's happening specifically within PCI and then within litigation in general. First of all, on PCI, I know we've seen a couple of developments in the last year in terms of case law and some of the decisions coming down. And maybe you could also comment on privilege and how we're seeing some of those. We had a full panel on it, but maybe specifically on how that's affecting the PFI versus the non-PFI distinction that you're seeing in the market.
Yeah, no, thanks, Paul. So I think sort of pinging off of Chad's discussion earlier about the value of credit card data, we're still seeing companies, retailers facing significant exposure in the PCI realm from the card brand assessments, the fines and issuer reimbursement assessments that get assessed on the acquiring bank in the first instance following a breach involving PCI data, and then get passed to a merchant through the merchant services agreement indemnification provisions. We've seen, even though with the advent of EMV, there's a reduced risk of fraud, and Visa and MasterCard have moved away from the fraud recovery programs. They still have operating expense, and they've increased the recovery per card on those programs. So the exposures for those assessments still remain, high in this, and can be, in the 6 to 7 figures for significant breach. So it's important, as you're thinking about preparing for an incident, for retailers to look at their merchant services agreements, because that's in the first instance where we're seeing a lot of disputes between merchants and those acquiring banks over whether those assessments and fines are actually covered by whatever indemnification or reimbursement provision is present. There have been a number of cases that have held that because of a limitation of liability provision, excluding consequential damages, or even the definition of what's covered, whether it's a fine, fee, penalty, or assessment, has turned on whether there's liability in the first instance. So knowing what your agreement with your acquiring bank requires you to cover is important, as well as your insurance, because as we've seen in some cases, even if you have a cyber insurance policy that provides for coverage, you may not have specific express coverage for a PCI DSS fine or assessment. So those are both things we've seen. But more recently, as you mentioned, Luehr, there have been a couple of decisions last year that are really important. In Texas state court, a case brought by Sally Beauty that Orrick handled, against Visa directly resulted in a decision by that Texas court, for the first time, holding that one of these assessment programs, the GCAR assessment program, is unenforceable, is an unenforceable, unlawful liquidated damages provision under California law. And that decision has been hotly contested and is on appeal right now with the Texas Court of Appeals, but could have implications for Visa and others. But also we've seen in class action litigation, because we've continued to see retailers facing claims both by consumers and cardholders as well as financial institutions. And in federal court in Ohio, Sonic was facing a class action brought by financial institutions. And that last year resulted in only the second time a class being certified of financial institutions, despite the differences in size and response and the various fact issues and individualized issues. The court there certified it. The only other time was in Target. Two other decisions in TJX and Fred's. The court declined to certify a class, and so that appeal also is subject to that decision is also subject to appeal, but that could have long-ranging ramifications for retailers as well. And then finally, I know we had a whole hour of intense and very illuminating discussion on privilege this morning, so I don't want to rehash all of that. But I do think, particularly in the PCI space, where under the card brand rules, retailers are required to retain the PCI forensic investigator, the PFI, that can often serve as that non-privileged business purpose investigation that they discussed, that will, when you're faced with a motion to compel or a challenge to the claim of privilege over an internal privilege investigation conducted by counsel, you can point to the separate PFI investigation. That was the investigation that was being done for business purpose. That's the forensic report that is being disclosed to third parties, and then allows you to have that sort of two-track differentiation in protecting the privilege, in addition to all the other points that were raised this morning.
That's great. And speaking of class actions, I know one hot issue has always been standing. And I think another one is the resurgence of class actions that we're seeing coming out of some of the privacy statutes, like the CCPA. Maybe you could speak to both of those. Where are we on standing these days, and how is that playing out?
Yeah, I mean, I think just now a couple of months ago, we had the 11th Circuit joining with the third, fourth, and eighth circuit and second in finding that an elevated risk of fraud on its own, without any attendant fraud or misuse, isn't sufficient to create standing, and even taking mitigation measures in response to a notice of a breach not being sufficient to create that injury. And that's important. You still have the 6th, 7th, and 9th circuits out there saying that the risk of fraud itself is sufficient. It's a significant issue. It's a threshold issue for whether these class actions can go forward. But it's just a federal issue. It's not a state issue. So you still face, it's not a catch-all defense, even where in these cases where standing doesn't exist. And I think, but it does sort of also highlight the issue with injury in fact, and that standing alone isn't enough, that the plaintiffs have to allege an actual injury that's sufficient to be cognizable under whatever particular theory of liability they're asserting. And then in addition, as you point out, CCPA, we've been tracking and following the explosion of cases. Not a lot of decisions giving us a good contour on where the law, how courts are going to be responding to these arguments. But really, we've seen, I'd say, two broad categories of cases. There's the straightforward claim asserting there's been a data breach under the private right of action, asserting recovery for the statutory damages of up to $750 per record in those cases, but also sort of more creative uses of the rest of the act, saying that a violation of the CCPA provisions, even if it doesn't give rise to the private right of action under the statute, could be the basis for a UCL claim, that a failure to comply with CCPA is the basis for an unlawful, unfair, or deceptive trade practice. or that the CCPA now establishes a duty under negligence that in many cases doesn't exist in state law, and to support that negligence claim. And I think also to keep our eye on the CPRA and where that's going. It's expanded the list of elements that could be actionable under the private right of action as well. Well, it's a couple of years off. That's also on the horizon as well to keep an eye on as you think about it.
Yeah, so some takeaways that I'm hearing are we have to pay attention to not just consumer class actions, but now things like financial institution class actions, which is a bit of a different animal. And we're going to have to pay attention to ways that folks might like to take some of these pure, what I think of as books and records, privacy type violations, and try to spin them into the private right of action that really exists, at least in California, and I think we'll see in other states, under the cybersecurity prong for data breaches in the traditional sense. We're going to have to watch to see how that plays out.
Right, and you've seen in Virginia and others that those same theories that I'm talking about being advanced in California could be the basis elsewhere, even without a private right of action. Exactly.
Right, and I think for those of you in retail, this is something particularly to pay attention to, because I was looking through the list of class actions that have been brought in California. It's somewhere around 100, give or take, and I would estimate maybe about half of those are actually very well-known names in the retail industry, big box retailers. I was looking at franchises that involved everything from barbecues to auto parts, and gaming platforms, which obviously is another retail outlet, especially for kids. And I don't know how this got in there, but it did catch my eye that Reese Witherspoon is also listed as a class action defendant. So a wide variety of people being brought into lawsuits under the CCPA, especially with those statutory damages. And as you say, we've seen where statutory damages take us, especially when we look at the TCPA environment. It's millions of dollars per case, especially if they're getting settled. So I think we all have to pay attention to that. For the last couple of minutes, I want to open it up to the group a little bit and ask just a general question. If you were the general counsel of a retail company out there in the business to consumer market, and you see all of this stuff going on, what's the advice that you would give them these days? Chad, maybe I'll start with you.
Yeah, Paul, if you asked me this question a week from now or a week ago, it might be a different answer, but there's going to be a panel later on this, and I'm going to maybe be the bridge to it. But B2C right now, cyber insurance is a crutch. You need it, you have to have it. But if you think transferring the financial risk is solving your problem, you haven't. You've got to be cyber ready and cyber secure and cut the probability of having an incident in the first place way down. And there's two reasons for that. Number one, you can't insure your goodwill, and you're in B2C. And I've had clients weeping on the phone with me because of the effect on their goodwill with their clients, and it's heartbreaking. And so this is a best defense play. But the other reason that I say that, and I can't wait to hear the insurance panel talk about it, is cyber insurance is going to get more and more expensive because of the panel right before us. The ransomware problem is making cyber insurance not the easy solve that it used to be. And so I'm hoping that just in this little short time that I'm able to address the people listening right now, I think everybody sort of has used the cyber insurance crutch for a while, and we can't afford to do that anymore because it's at least partially going to get kicked out from under us. Ironic that I say that, considering that I work for a company owned by Aon. And number two, because I am also so adamant with the second statement, which is you better have cyber insurance. So Paul, that's what I'd say.
Seth, how about you? You're the general counsel going to the retail CEO. What's your advice?
I mean, I think it's to be, to recognize, I think Kevin said this a little bit more, every company sort of has to have an assumption that they're going to be breached. You have to have, a plan, and it's sort of it's about not about whether you're breached, but about the severity of the breach and how to limit the exposure, both from an incident response, the systems, the data that could be exposed, as well as your liability exposure. I agree with Chad. You have to have insurance, but it's not a catch-all. You really have to have a comprehensive whole approach to dealing with it.
And Kevin, for you, I'm going to switch it up a little bit because this came from one of the audience members. They rephrased the question like this: what keeps the FTC up at night?
What's going to keep me up is that somebody said, I want a transcript of this so I can remember Kevin's statement and put it back in it. I just looked that up just now, and I don't know when they made that comment. So that's what's going to keep me up at night. But no, I think everybody has made some great insights of what they would tell the CEO, and I agree.
And I would add just one thing, and that is, do you actually know where your data is? With the profusion of different marketing options that are out there, I think we're all collecting a lot more information. Our clients are collecting a lot more information. If we think we've got our arms around it, we're probably wrong. And I think the data breach statutes are going to prove us wrong over time. It's amazing to me that, for example, only North Dakota and Washington State count date of birth as a trigger for data breach notification. Whereas if you go to the average person on the street, they probably would elevate that a lot higher. I think that list of potentially sensitive data is going to get longer. And as it gets longer, I think companies need to make sure they've taken an inventory of data, they know where it is so that they can better protect it. And I think, let me see here.
Right here, Paul.
There he is. With that, I will hand it back to Bruce. Thanks very much.
Thank you so much, Paul. Great job moderating. And to Chad, Seth, Kevin, that was a terrific panel. Maybe the best retail panel I've heard. So thank you all very much for your insights.
Sure.
Our next panel is on national security. It should be a really good one. It's on, begins at 3:05 Eastern. So we'll see everybody back here in just a few minutes. Thank you.